Number 68, People v. Rakeem Douglas.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Rakeem Douglas. Mr. Douglas's conviction should be vacated because the warrantless search of his car was carried out pursuant to a facially unconstitutional inventory search protocol. An inventory search is only as lawful as the protocol that authorizes it. It's the prosecution's burden to introduce that protocol in the first instance. This protocol, which was introduced, Section 218.13 of the NYPD, NYPD Protocol Section 218.13, provides no guidance to police officers about what they're supposed to do with property after it's taken out of a car and before it's vouchered. So what that looks like...
Before we get into the substantive issues, so again, is your argument that it's as applied or on its face that it's unconstitutional?
It's a facial challenge to the protocol.
So you are not bringing an as-applied challenge?
No, this is a facial challenge to the protocol as
only.
written. I'm sorry?
I'm just trying to understand, is it exclusively a facial challenge and does not include an as-applied challenge?
That's correct.
Okay.
Why are you not making an as-applied challenge, just out of curiosity?
My understanding of the law is that if the protocol is valid and the police follow it, it's a lawful inventory search. And so what's odd here is that they followed this protocol because the protocol says nothing about what they're supposed to do with the property between the time they recover it and the time they voucher it.
So the difficulty I've been having, I guess, with this case, we're here for re-argument, is that when you were attempting to make a facial challenge in the court of instance, the court said essentially, we're not having a referendum on this policy. And it seemed to me that likely you, but I think certainly the people, were then some combination or something in between precluded from or dissuaded from creating a full record that might have been created for a facial challenge. So if all you're making is a facial challenge, I'm worried that we don't have a record good enough to decide that challenge.
I think we do, because all we need to decide the challenge is the protocol, and the protocol is in the record.
Does the protocol have to be exclusively in writing?
It doesn't have to be, but of course they've also offered in this case what they believe to be the supplements necessary, Section 218.01. But the problem with that section is that it doesn't govern anything the police do with property before it's vouchered.
Counsel, also, just am I correct that conversation, I may be wrong, but the conversation I think the Chief Judge is alluding to took place after the close of evidence in the hearing, when the judge said, oh, I'm not hearing about the protocol. So it wasn't that he was precluding evidence that you were going to put in. I thought that was a statement made after the close of the hearing.
It was during argument. So he asked for defense counsel's argument. Counsel argued, began to make a facial challenge. The court immediately said, we will not be doing that, move on.
But it wasn't a case of there wasn't evidence put in that you wanted to argue. The hearing was closed at that point in terms of evidence, right?
Yes, the hearing had been completed. And I want to make the point that it is the prosecution's burden to actually submit a constitutionally valid protocol. They submitted the section of the patrol guide titled Inventory Searches of Automobiles. That is what it is called. That challenge has been made, and now, for the first time on appeal, they're offering this other section. The problem is that other section doesn't actually address what the police do with property before it's vouchered.
So is your position that in every case in which there is a challenge, that the people have to mount a full-fledged defense and explanation of the protocol, and then either you have a facial challenge that lies to that protocol or no challenge at all?
So my position is that the law says that the prosecution must establish, in the first instance, a constitutionally sufficient protocol. So they must introduce that into evidence at the hearing. Now, it's up to the defense counsel to challenge it or not on a facial level. In this case, we did. In some cases, they might not. But no matter what, it's the prosecution's burden to put that protocol into the record in some form.
I think your point was you could make an as-applied challenge, but your argument here wasn't they didn't comply with that protocol. It's that the protocol itself is unconstitutional.
Exactly. So the protocol itself is unconstitutional because the purposes of an inventory search are to secure property and to prevent the police from being sued for claims of loss or theft.
So what provisions exactly do you think would need to be added to make the protocol, in your view, constitutional? Would there have to be a limit, specific hours, or just a reasonable period of time?
So I think that actually it just needs to be amended very simply to say that after the police remove property from a car, they must secure it by placing it in some secure...
Stay, if you would, for a moment with the timeliness first.
Sure.
Okay.
So for timeliness, I think that the Supreme Court requires that it be done within a reasonable period of time.
And in your view, does that have to be expressly included explicitly in the protocol?
I don't think an hour number has to be. I think the word's a reasonable period of time, but we also think that if the police secure the property, if they place it in an evidence locker or somewhere where it can't be tampered with, then that time period can be more flexible because nothing's going to happen to the property while it's
Is your
secure.
view that the protocol has to expressly state that the property has to be secured, or is a practice of securing it sufficient?
I believe it has to, I believe it needs to tell the police to secure it, because in this case, as you can see, it doesn't. And then when Officer Burgos is asked, what do you consider inventorying the property? And he says, putting it in a plastic bag and leaving it for 11 hours in a precinct. And if that's what the police consider securing it, that's not secure.
So it doesn't just have to say securing, it has to include some minimal concept of what that means?
I would think so, because, I mean, and also this is not an unusual thing, right? Other parts of the patrol guide are pretty extensive about how to secure property. Like if you look at the section they admitted, 21801, which is about what happens after they voucher it, right? In this case, it sits for 11 hours, then they voucher it. Once it's vouchered, 21801 takes over. It's very detailed about what happens.
I guess what I'm grappling with is the difference between a protocol that, in your view, is insufficient and failure to comply with the protocol. So, for example, if the protocol said reasonable period of time, could you argue that the 11 hours here was not reasonable in light of the circumstances?
Oh, I think we could, yes. I think if the protocol actually required a reasonable amount of time, we would argue that this is unreasonable.
And if the protocol said you have to secure or safeguard the property, you could argue they didn't do that in this circumstance.
That's correct. But my reading of the law is that if the police follow the protocol, the only legal question is the sufficiency of the protocol. Here it's insufficient because there's nothing about what the police are supposed to do. And I want to turn this court's attention, if I can, to...
Can I just ask you, on the protocol, it says under sub 3, remove all valuables from the vehicle and invoice on a separate property clerk invoice. So it's not true that there's no direction as to what to do.
Yes, but the problem is that they don't tell them when they have to do it or when they have to make the property voucher or what they're supposed to do with the property until they make the voucher. So like in this case, the voucher wasn't made for 11 hours. In other cases, I mean, we want to point this court's attention to Ex parte Boyd, the Supreme Court of Alabama case. We know it's not binding, but we think it's instructive. And there it was 4 days, right? It just sat and waited. And they make the point that the longer the period of time passing between when the police take custody of the vehicle and when the vehicle's contents are cataloged, the greater the opportunity the property will be stolen, damaged, tampered with,
In this
spoiled.
particular instance, the idea of the protocol is so that you can produce a usable inventory list. And here, are you saying that what was done here, the 11 hours, caused it to be such that there wasn't a valid usable list that was produced?
So because it's a facial challenge, we're not challenging whether this particular list was usable. At the same time, I do want to make the point that
But
this-
even with the facial challenge, the purpose is to get a list.
That's right. So I want to get into what I think the problem here is that let's say, because this protocol says nothing about how much time will pass or what will happen to the property until it's vouchered, let's say it sits in a precinct in a bag for 3 days and the officer comes back and says, okay, it's time to voucher this property, and he makes the list. At that point, there is no way to know whether what's in that bag was what was actually taken out of the car. It could have been, items could have been thrown away, could have been added to. There are lots of things that could happen. There's no way an officer making a list will know, unless he has an extraordinary memory. He is not going to remember whether what he took out of that car is what's in that bag. The whole purpose of an inventory search protocol is to prevent that kind of uncertainty. It's a warrant substitute, right? We allow police to do this because it's the
So
structured...
your argument is because reasonable time isn't included, it creates that uncertainty?
It's not just reasonable time, it's actually primarily that there's no provision for the security of the property during that time, right? Because then it can just sit unattended.
So your primary focus is security.
Yes. We think that the time matters because of the fact that it's unsecured, for how long it can sit without being dealt with. And that's when the kind of outcomes inventory search protocols are supposed to prevent, that's when they actually happen.
I think last time during argument, you were asked about the time, how long can property be in a secure location before vouchering, and I think you said that the police can take the time they need to take as long as the property is secured.
I think the limitation is...
Is that statement still true, or are you changing it now?
No, I think what we said that, but then we also mentioned, of course, the Supreme Court says it has to be a reasonable amount of time, so that limitation comes in. But I do believe reasonable gets adjudicated on a case-by-case basis, so we're not trying to impose like a specific hour number or anything like that. Thank you, Your Honors.
Thank you.
Good afternoon. May it please the court, Stephen Kress on behalf of the people. So defense counsel said it is our burden to establish a valid inventory search procedure. Yes, absolutely it is. If the defense feels we have not done that, it is the defense's burden to object and point that out. And the defendant simply never made the facial challenge that he's making now below. And I think that's important because by not making that challenge, we didn't then have an opportunity to put in additional evidence that we could have put in to
Well,
develop.
the judge didn't allow him to make the challenge.
I don't agree with that, Judge Singas. So yes, the judge does say we're not going to have a referendum about this.
Correct.
However, 3 pages later in the transcript, defense counsel says, well, actually, Judge, I am going to make a facial challenge. And then he goes on to say that the inventory search protocol gives the police officers too much discretion in how they do the search. He had an opportunity to make the facial challenge he's making now. He didn't do it. He made a different challenge. He never said anything about, well, this doesn't talk about, securing property, and so therefore it doesn't
So
achieve.
arguing about, and generally how was insufficient to preserve specifically securing the item?
Yes, Your Honor. I think it has to be the specific argument, and this specific argument was not raised. So,
Can you, is there anything in the protocol that requires the police to secure the property?
I would say there is, Your Honor. And so,
Where in the record could you point us to?
so if you look at the patrol guide itself, the very first part of it says purpose, and it says to protect property, ensure against unwarranted claims of theft, and protect uniformed members of the service and others against dangerous instrumentalities.
And is there a page of the appendix that you're on that you might help me
Yes,
with?
it's page 156.
Thank you.
So I think by setting forth at the very beginning, this is the purpose, this is the reason why we're doing this search, is to protect property and ensure against claims of theft or loss. I think any rational police officer, and let me just pause and say, the test is whether this protocol is rationally designed, not necessarily perfectly designed, but is it rationally designed to achieve the goals of an inventory search? And I think any rational police officer reading this and saying, okay, the purpose of this is to protect property and ensure against claims of loss or theft, no rational police officer is then going to say, oh, okay, well, after I take these items out of the car, I can just leave them completely unsecured in the station house indefinitely. I don't think that is reasonable to read from this. So,
And what about a limitation on the time that it takes, a reasonableness constraint or something like that?
so the law imposes one already, Your Honor, as defense counsel mentioned, and I don't think that has to be expressly included if it is already a legal obligation that is imposed on the police.
So is your view that it is not in fact included, or is it included somewhere explicitly? I understand you're saying it doesn't need to be, but is it included explicitly?
I mean, I think if you look at 218.01, I think that does imply that the inventorying process is supposed to be done, I wouldn't say simultaneously, but contemporaneously with the removal of the property, because it says upon taking into custody. But yes, I think even if it does not expressly say reasonableness, I think since the law imposes that requirement, that wouldn't render this, again, not rationally designed to achieve the goal.
And do you have to do the same thing for securing? Do you have to go look to other sections of the patrol guide to get a working definition? The word secured is not in 218, is it?
No, well, the word protect is in the purpose. It says to protect property.
That's yeah, well, that's sort of like a preamble-ish, what the purpose of the regulation is. But there's no instruction to secure property in the patrol guide, is there?
Not verbatim, Your Honor, but I think by defining the purpose, I think the policy is
So
impressing.
it's implied?
Yes, I think it is. I think it's impressing upon officers that this is their obligation, and in fact, both of the officers in this case testified that that was their understanding, that this was the reason why they're doing this search, and as a result, they had an obligation to safeguard the
And
defendant's
then,
property.
counsel, do you have to go look to other sections of the patrol guide for a definition, for an explanation of what that implied concept of secured is?
In other words, like,
And my last question will be, and if that is so, was that complied with here?
so let me just make sure I understand. So are you asking, is there a definition of what it means to protect or to
Your
safeguard?
adversary mentioned during oral argument, when he was being asked about what secured is, he said you can look to other provisions of the patrol guide to get a sense of what that means, what that word means in this context. And I'm asking you, is that statement true, that you can look to other sections of the patrol guide, and is it your argument that that's what needs to be done for an officer who's fulfilling their duty to comply with this regulation?
Okay, I do agree. I think other sections of the patrol guide do talk specifically about how certain items, like firearms, for example, how those are supposed to be safeguarded. But I don't think that you necessarily have to look to those other provisions when you're talking about generic property. You know, like in this case, there were some items of clothing and other personal items that were taken from the car. I don't think you need to look at another section to say, like, okay, those items have to be, placed in a particular location or a particular type of security. I think that that would get into, I think it would really be micromanaging, and I think it's not curbing discretion.
So then you're saying those other provisions would not apply?
I think if I'm remembering correctly, I think they deal specifically with particular types of evidence, so you could secure property that way, but I don't think it necessarily would have to be done in the same way.
Then does it create some ambiguity? That there are sections that are particular to certain types of property that would leave an officer wondering, what am I to do with something that doesn't fall within those definitions?
No, I think they would understand they have to protect it or safeguard it in some way.
But that would be true, let's just take the gun, I think you said a gun, a weapon, okay? That would be true about a weapon, but obviously, some higher up, the drafters of the policy decided that they thought it was necessary to explain how to do that. So, as I'm saying, without the explanation for these other types of properties, does that leave a certain, does that leave the officer uncertain about how to protect the property? When there are other sections explicitly telling you how to do that?
I don't think it would leave them uncertain if if the property that this officer is dealing with doesn't fall into that specific category. I mean, the officer here would know this isn't a gun, so I don't have to necessarily put it in a safe, but I don't think he would be left uncertain about.
Well, how would they know what's the minimal way to protect this property? The minimum thing that they have to do?
I don't think that, so I think the question you're getting at
Your
is,
answer is that you've got this other section, an officer would understand that if it's not a weapon, okay, I don't have to do those things, but how would an officer know from what's in the record, what's available to them under the policy, what is at least the minimum that they'd have to do?
I mean, I think they would just understand from the purpose of this protocol. Again, we're talking about, we don't want property to be damaged, stolen, contaminated with in some way. So you have to do something to prevent that. And I don't think you need to say, that means you have to, at the very least, keep it on your, keep it in your eyesight the entire time, or you have to put it in a particular location. I think the discretion that GALAC in particular talks about, they talk about limiting officer discretion with respect to what is searched and what is seized. And here, the search is over and the seizure is over at this point. And so I think by trying to establish uniformity or some sort of minimum level about, protecting property afterwards, I don't think it's advancing the Fourth Amendment interests that are at stake here, or the state constitutional interests are at stake, which apply to arbitrary searches and seizures, since the search is over and the seizure is over. And unless there are any other questions from the court, I would ask that the judgment of the First Department be affirmed.
Thank you.
I believe I forgot to reserve rebuttal time. I don't know if there's the possibility of getting any, but I don't think so.
Why don't we give you a minute?
Sure. My mistake. 2 points very quickly. First is that GALAC actually explicitly holds that what the police do with the property after it's seized is a part of the Fourth Amendment inventory search inquiry. So that's an explicit holding on page 271 of the GALAC decision. So yes, it is relevant. The second thing is that nothing in the patrol guide anywhere says that a property must be secured before it is vouchered. And it provides no time limit for when the vouchering must happen. So the point here is that when we said other parts of the patrol guide say how to secure property, the point we're trying to make is that it's actually not micromanaging. The police know how to put property in an evidence locker for an extended period of time if they have to. That's a simple thing to do. If we say, or this court could issue a holding saying, the protocol has to make provision for the security of the property until it is vouchered, and it must be vouchered within a reasonable amount of time. That is an easy thing for the NYPD to do. The reason I brought up 21801 is because it shows that after it's vouchered, they give it to a property clerk, the property clerk holds on to it until it goes to the next person down the line. That's a pretty straightforward process. It's a few sentences. The problem is that there's nothing in this patrol guide that tells the police to do that until they voucher it. And in this case, you see what happens. It sits for 11 hours in a garbage bag. In the future, it could be 4 days, 3 days, depending on what the police officer considers to be his priorities at that time. That's the kind of discretion that's not supposed to be in the protocol. Specifically, that's the problem here. And I want to reiterate, GALAC explicitly says that's a problem that has to be dealt with. Thank you, Your Honors.